All right. Let's get this going. Good afternoon. Good to see everybody out. Thank y'all for your patience today. I'm going to call on Secretary Crow to open us up in a word of prayer. Which?
Borrow her microphone. Okay. Let us pray. Dear Lord, thank you for allowing us the honor and privilege to be here today to work on the laws of the state of Georgia on behalf of the citizens of the state, Lord. Lead us, guide us, direct us. Let our deliberations be done in good faith. Let us do them in a way that be pleasing to you, and let us always keep in mind that we're here working for the people of the state of Georgia. In Jesus' name, amen.
Amen. All right. First one we're going to hear is House Bill 1079, Chairman Petrie.
Thank you, Chairman.
Just tell us which LC number you're working on.
Yes, sir. Thank you, Chairman. This is LC 442597. It went through a while back subcommittee, and this is the companion bill has already been through the Senate, but we want to make sure we get this done. It's very important to my community. This is a bill that relates to the abatement of nuisances, and as you'll see here, Mr. Chairman, we have changed this. What we're doing here is making sure that the local government, where you have in current statute that private citizens can pursue a claim for a public nuisance, we basically are granting that authority for local government to do so as it relates to events that are hosted by promoters or organizers that are not properly permitted. So we have these events that are unpermitted that create a great deal of disruption to the community. This is something that's been happening on Tybee Island as a good example, where we have 110,000 people on a 3-mile island that's 1 mile wide. One road access, and so great calamity as it relates to roads, law enforcement, drug overdoses, cleanup, toileting facilities. All of these things end up costing. The last one was $187,000 for the city of Tybee, and so what this would allow is the local government to seek civil recourse, similar to what we did with streetcar racing, by the way, in that bill in the past, to hold promoters, these social media-driven promoters and organizers, accountable for the event, so they have some recourse. That's very simply what it does, Mr. Chairman. Glad to answer any questions.
All right, thank you. Number 13.
Motion at the appropriate time.
Okay. Number 14, Representative Byrd.
Thank you, Mr. Chairman. Thank you for once again bringing this forward, and I think this kind of, I touched on this the last time. So in my neighborhood, I have 1,400 houses. Oftentimes the community gets together to have a Christmas parade, some sort of event. The entire community participates. So if someone happens to come in and causes trouble, we have to call the police in. Someone's going to have to pay for that. Is that correct?
I don't know, Representative Byrd, if it would cover that. This is where a promoter or an organizer drives people to an event and has an impact on local government. So it wouldn't necessarily be something that would be recourse from a neighborhood, but if local government chose to pursue that, they could. So it may be some of the legal minds here might be better able to answer that in that circumstance, but certainly would allow a local government to do so when it's unpermitted. And I use the example of the example what we have with the St. Patrick's Day parade. We have one of the largest parades in the country, but it's all permitted and everything is in place and all the law enforcement is there and all of the issues are prepared, and so you're able to manage it. When these things occur and there's no preparation, it creates absolute chaos for the people that live there, to your point. So I understand that, but I don't know that I could speak fully to that example. And Mr. Chairman, unless some of you guys could speak to that.
I think my understanding is, Representative Byrd, you were at the first subcommittee on this bill?
I was.
Okay. I think the gentlelady's had enough time to talk with the sponsor. If you want to talk with her offline, that's fine. Number
We
11.
can get an answer on that. Let's get an answer.
Vice Chairman Silcock.
Yeah, Mr. Chairman, I guess I would just want to clarify that I think this is an event that's advertised for a public space. When they're in a public space, that would
Yes.
be the kind of controlling factor, I think.
Good point, and that's why I can't concretely answer Representative Burr's question, because it is a public
Understand.
beach.
Right, exactly.
But it's not all, just the beach.
Right.
Not the balance of the island is not. But it's
Exactly.
all impacted. So I think that question is a good one that might take a little more digging to understand the answer to. But that's a great point, Representative. Thank you.
Number 16. Chairman Leverett.
Thank you, Mr. Chairman. I just was going to comment. I think the conditions in paragraph B and the recoverable expenses in paragraph 2 would probably keep Representative Byrd's neighborhood event safe, because it says that it's got to be hosted by a promoter or organization that's not properly permitted, and it has to result in a public nuisance that impedes travel by police, fire service, emergency medical services personnel, or other public safety personnel, or sort of a governmental employee. And then the only thing they could recover are expenses associated with public safety. So I don't imagine your event probably causes that much ruckus, even though I bet it's fun.
Number 8.
Thank you.
Representative Miller.
Thank you, Chairman.
Thank you. Thank you. Thank you for your bill. Thank you for coming back today. Just a
ma'am.
quick question for you in line 16, where we talk about a promoter or an organizer. Brian and I were just talking about the definition for a promoter and organizer. It looks like promoter is pretty clearly defined in our code.
Right.
Would the term organizer be sort of like a Webster's definition of organizer, or are these two synonyms? In other
Well,
words,
to me, they're synonymous. I can't speak, full well to that. Maybe someone with legislative counsel could. Our goal here, though, to be clear from the start with legislative counsel, was an individual who is they're financially making money and promoting and organizing this event. They drive people to these events, and they actually benefit financially from organizing these events. So I can't speak more deeply than that, but clearly that person that is driving people to this event, when they know it's unpermitted, they've refused to seek permitting. They've just avoided the process that's available to everybody, by the way. So it is those individuals.
All right. Seeing no more questions, I know we've had a lot of testimony. Remember, there was a Senate bill that we heard that was the exact same bill, so we wore this out worse than a mule on the back 40.
Same language, Mr. Chairman.
So, Representative Neal.
I move.
All right. What kind of move?
Do pass.
All right.
The right
We got a move to pass in a second. All those in favor of the bill say aye. Aye. All those opposed, same sign. Congratulations,
Thank
Mr.
you, Chairman,
Chair.
and to all of you. Thank you.
All right.
Absolutely, I'm ready on one or more.
Yes, sir. I'll come right back to you. Just hold on a second. Oh, yeah. All right. Vice Chairman Reeves.
Thank you, Mr. Chairman. Would 1383 be the best one to present?
Go ahead with House Bill 446.
446, House Bill 446 is drive-by shooting bill. I appreciate the level of time that members of the committee have put in this, as well as Prosecuting Attorneys Council and Georgia Association of Criminal Defense Lawyers. This bill gives some specific language that can be used in prosecution and jury instructions regarding drive-by shootings, and it adds some better law to make sure we have convictions on these terrible crimes that endanger homes and businesses. A lot of work's been put into it, and would appreciate your passage.
All right. Any discussion from members of the committee? Seeing none. I know we've had. All right. Move to pass second. All those in favor say aye. All those opposed, same sign. Congratulations, Mr. Vice Chairman.
Thank you.
All right. Next, go ahead and tell us about House Bill 656.
Thank you, Mr. Chairman. House Bill 656 came from Representative Darlene Taylor and a police chief, and now a sheriff also from Southwest Georgia. This bill is a narrower bill than a previous version you saw. This merely addresses people who cross state lines with plans to molest a child, and they do not reach the opportunity of laying hands on that child. Alabama and Florida, our sister states in the 11th Circuit, have a law similar to House Bill 656, which allows prosecution of people who have an unsuccessful attempt to molest a child in Georgia when they've traveled across state lines with those plans. That would have to be proven beyond a reasonable doubt, but we've got text and other electronic things now that would have a paper trail for those kind of convictions. Respectfully request your approval.
Okay, number 17.
I think I like the bill. Are they able to prosecute today, or is it just more difficult to prosecute without this?
There's attempted child molestation, but there are some limitations of that crime. There are some federal statutes that get in this arena, but this is a specific state statute that gives specific warning to child molesters who are crossing here from the several states that adjoin Georgia. Stay out of here. Don't come here with plans to molest a child.
Okay, thank you.
All right. I see no more questions. No, number 6.
I move to pass.
All right, move to pass second. All those in favor say aye.
Aye.
All those opposed, same sign. Congratulations, you're on the rules.
Thank you.
All righty. Let's see, which one? Oh, yes.
Chairman, I'd like to motion to reconsider SB 332.
All right, I got a motion to reconsider. Motion second to reconsider Senate Bill 332. All those in favor say aye. Aye. All those opposed, no. No. And the opinion of the chair, the ayes have it. Majority Whip, Senator Randy Robertson. Come on back.
Thank you, Mr. Chairman. SB 332 has not changed since the last time I had the honor of sitting before you. All I'm doing in the bill is following the instructions of the Georgia Supreme Court and removing them from the process that we encompassed when we first passed the legislation last session.
Man, this senator wants a bill passed in this committee, it sounds like. Thank you for your brevity.
Yes, sir. Thank
I know
you.
you could recite it in your sleep, and Miss Teresa probably gets tired of hearing you recite it in your sleep. Number 17.
Motion to pass.
Got a move to pass. Motion second. All those in favor of the bill say aye. Aye. All those opposed, same sign. No. And the opinion of the chair, the ayes have it.
Thank
Congratulations,
you, Mr. Chair.
you're
Thank
on
you,
the
committee.
rules. What? Moving on, moving right along. Let's see. House Bill 1130, Representative Holcomb. Senator Robertson, who's carrying this bill for you in the House?
That would be the Honorable Joseph Gullett.
Sounds good. All right, sorry for that. Representative Holcomb.
Thank you, Mr. Chairman, members of the committee. It's my pleasure to present to you House Bill 1130. What this would do is it would provide a path for victims of human trafficking to seek immunity prior to being prosecuted. Victims of human trafficking do not have free will. They are controlled by others. There will be a bill on the floor tomorrow. I forget the number, but Chairman Gaines is carrying it, and it provides for vacator after somebody has been prosecuted. So the idea behind this would be at the front end to allow somebody who is a victim of trafficking to raise that before the court. They would have to do so through a motion, and they would also have to demonstrate that that crime is committed as a direct result of their trafficking. There are only 2 states that have this so far. It is an area of the law that is developing fairly slowly. Those 2 states are Nebraska and Wyoming. I know that the subcommittee had it, the full committee may or may not, but there was a memorandum prepared by the Wilbanks Child Endangerment and Sexual Exploitation Clinic, which is a preeminent scholarly research tank that looks at these issues, and they analyzed Georgia's overall laws on human trafficking, and their recommendation was that we do this instead of an affirmative defense. So I'd be happy to answer any questions, but that's the idea.
How much opposition do you have in subcommittee?
There was none in subcommittee. I have heard some private concerns, but I have not heard any public concerns. I don't know if we will today or
Okay,
not.
understood. Number 16. Chairman Leverett.
Thank you, Mr. Chairman. So I gather this is a, this would be a motion that the victim would file as a defendant in a prosecution.
That's exactly right.
So, and then they could have an adjudication of immunity. So to your point, I was thinking before lawsuits, before the criminal prosecution's filed, but this would be after the, accusation or indictment, but prior to adjudication of the charge, they could get a declaration of immunity.
That's exactly right. And then if they failed, then they would just move forward with the prosecution itself. And there's a couple of other things that I would just highlight for the committee, because this is a little bit complicated. We want to get it right, certainly, is 16-2-21. Part of the intent would be not to have the victims of trafficking be prosecuted, but to have those who direct it, the traffickers. And 16-2-21 already provides for the prosecution of parties who did not directly commit the crime. That's already in our statute. So the way that I would hope this would work, and we'll see if it passes and in terms of reality, would be that if this was raised, then they would provide information and then prosecute the traffickers. So it should help us to build cases, and prosecutors also have an ability to strike immunity deals for testimony and everything else. So I think that this is sort of consistent with the overall framework that we have.
All right, number 17. Representative Gill.
Some of these crimes could be potentially like prostitution. They get arrested in a prostitution ring, but they're human trafficked. This would give them the ability to file for immunity in that situation, hopefully turn over the pimp or the mom or whoever it is that's doing this, and allow for them to get help as a victim and not be prosecuted as a prostitute. Is that like
that's
a
exactly
potential situation?
It is. That is a common situation, and I will also highlight that we have an affirmative defense for that.
Okay.
And so instead of having them go through trial, get convicted, or not convicted, raise the affirmative defense, this would be done on the front end
Right.
instead of having to put them through that.
Great, thank you.
Number 11. Chairman Silcox.
Thank you, Mr. Chairman. I was just going to add that I do think that this is a great piece of legislation, because I think that this, the fear that the victims have so often to particularly confront their traffickers, that this would allow that person to be removed from that adjudication process, possibly by giving them immunity. And I think giving them immunity, you will get a lot more out of them than you would have without that protection. So I appreciate you bringing it.
I agree. Thank you.
All right. Seeing no other questions, move to pass. Second. Do I hear a second? Before I forget, my favorite retired prosecutor has signed up to speak to this, so I'm going to allow him to speak before the vote. Just because I miss him so much.
Thank you, Mr. Chairman. I appreciate it, and thank you, Representative Holcomb, for bringing this. I will say that Representative Holcomb has always been a really solid ally for us on a lot of bills. We do have a little bit of a problem with this bill that I've discussed with Representative Holcomb, and that is by having this immunity, just blanket immunity like this, what happens when you have a trafficking victim who commits a crime against another trafficking victim? And then if you have a trafficking victim who has murdered a human trafficking victim, and they automatically get immunity. And I know the goal is to try to go up the chain, but once you have that immunity hearing, there's no need for that person to testify. What happens when you have a human trafficker who orders a person who's been trafficked to commit a crime on behalf of that organization? Well, then you have that immunity standard again. I'm not saying I'm completely opposed to this bill. I am asking this committee to table it so I can work with the sponsor and maybe look at it. I haven't seen the other two states that have passed similar bills to this. I don't know that it's a bad idea, but I don't know that it's a good idea because it has so many unintended consequences that could develop just by crimes being committed. What happens when a human trafficking victim rapes a human trafficking victim? Automatically you come in, you have an immunity, and you'll have an immunity here. If they're granted immunity, that you're kind of opening up a Pandora's box here.
Number 14.
Thank you. That was some of my concern looking at it. It doesn't seem to be a list or limit on the crimes that they could gain immunity from. If they're being sex trafficked and they're ordered to murder someone, or another sex trafficking victim, that's a little concerning that that it's kind of holistic. And I know that they would have to go and have the motion to present evidence in a hearing, and the judge would make that determination, I guess. But I don't know. I feel like I need to think about it a little more. That there are some crimes that I just don't know that I don't know, that maybe they shouldn't be immune from.
And I also have another concern, which is that you have, which has now slipped my mind because I'm getting old and tired. I can't remember what it was. I'm sorry, I can't remember. It'll come to me.
I think if I could respond, and I know you're in full committee and we usually do this type of vetting in the subcommittee, I think the limitation of the direct result of being the victim is appropriately tailored to limit those circumstances. So if a victim of human trafficking were to rape another victim of human trafficking, I would not take the position that that was directly related. Others might disagree, but there's not a lot of case law on this. In Wisconsin, they have an affirmative defense that is very similar, that grants a defense across the board. And they found in a case involving a murder, in examining the direct result languages, that they held that it needs to be a logical causal connection between the offense and the trafficking, such that the offense was not the result in significant part of other events, circumstances, or considerations apart from the trafficking. And I think as this area of law develops across the country, we'll get some more guardrails in terms of making sure that this doesn't provide for the circumstances where it could be misused, but rather there really has to be a nexus to the trafficking itself. So I also would say that my other response in terms of the issue regarding the ability to have conversations with the victims, my sense, and I think most of you know, is I'm a former prosecutor too, I think the conversations would be stronger at the beginning to be able to strike deals with them at this early stage, maybe even before this motion goes forward. But a defense attorney could raise it, say, I have a human trafficking victim who only did this because of it. Let's have a conversation and let's see how I can help you get those that really are the problem makers and the traffickers, which should be the goal of the state. So certainly whatever the committee wants to do, if you want to examine it more, that won't hurt my feelings. I always want us to make the best policy as possible. And to that end, I would just go back to, this is drafted by the experts. Like, the experts put this forward. And so I would put a lot of stock in that. And then the other part of it is, hopefully I've demonstrated over the years some level of reasonableness and being willing to listen. So if there was an intent to move the bill forward, certainly if we get over to the Senate side, you'd have my word that I'd be willing to do that too, as a different option.
Number 6. Representative Neal.
Thank you to the chair, and thank you to the author. I'm very familiar with all of the work you've done in this space. Very well done, very well respected. So I have 3 options. Option 1, I do think this is tight enough, to your point, but if there is a change that can be recommended, and please advise how you feel, on lines 15 through 17, a person who commits an offense as a direct result, yada, 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 get to 17, therefore, back up 16, shall be immune from criminal prosecution.
Is yada, yada, yada part of the...
I was trying to get us through. Right. 16546 shall be immune from criminal prosecution. Strike, therefore, insert, except in instances where the crime does not directly correlate to crimes under 16546, and that's the trafficking code. So to cover your point and some of your concerns, you get immunity except in instances where the crime does not correlate with actual trafficking. So that covers victim on victim crime, I think what you mentioned, and a few others. Just crafting the exception just says that if it does not relate to crimes under 16546, which is trafficking.
I think so.
So that's 16, immune from criminal prosecution, except in instances where the crime does not directly correlate to crimes under 16546.
I'm not sure I understand it.
So we're
how
I'm
that's
trying
going-
to carve out the exception that
Right.
some of the members have referenced. And so by doing that, it makes it where you only get immunity if your crime is actually, if you're actually a victim of trafficking.
Okay.
I'm not sure that cures some of the issues that I'm concerned about.
What does
Okay.
Bill
I'm
Arthur think?
Okay.
I'll come back to you,
The
Pete.
third, the third option is,
Hold on a second. I
Go
want to
ahead.
hear what the
go ahead.
Bill Arthur thinks about that one.
I think it's already built in, and just for the committee's benefit, 16.5-46 is the precise part of the code on human trafficking itself. So I think it already says that, but certainly if the committee had a different view, I wouldn't object.
Okay. All right, number 14. Secretary Crowe.
So either to the author or Mr. Scandalakis, is there a limit on how many times this could be used to gain immunity for different charges? I mean, could it be done more than once? I mean, I don't want this to become a tool that can be used multiple times to keep, gaining immunity. Does that make sense?
I'll defer to Representative Holcomb because
It doesn't currently address that, and I think part of what we were thinking was that the victims would then get services and would move out. I would certainly be supportive if you wanted to have some language to state that it could only be used once. The only hesitation that I have with that, though, is let's say an individual raises an immunity defense, it wasn't adopted, the person goes to jail, the person gets released, and then unfortunately goes right back into trafficking. I also don't know that I would want to limit that person from having legal rights because they're not free if they're a victim of trafficking. So that's what makes it a little bit complicated. I certainly understand what you're saying, and I don't want it to be misused. I don't think any of us want it to be misused, but certainly I'd be open to a way to revise it if y'all could think of, a circumstance where that might take place. My sense is it would be highly, highly, highly improbable for that to happen.
I mean, the only thing that I can think of is that, and again, I'm using worst case scenario, but I've been doing this a long time, and I'm very sympathetic to victims of human trafficking, but there are some actors that will use this to their advantage to commit crimes. At one time, they may have been trafficked, but now they have voluntarily gone into this line of business, and they'll use it for their advantage. And I'm just concerned about the unintended consequences of a good bill. And Representative Holcomb has been nothing but supportive of victims and sexual assault kits and getting everything done. And it hurts me badly to be up here on a side opposite of one of his bills, but I just think this has unintended consequences.
Floor Leader Hong.
Thank you, Chairman. I fully am confident that Representative Holcomb will continue to work on this and listen. And with that, I have a motion at the right time. I haven't done a motion, but at the right time, I will, if it is the right time. But thank you.
She just wanted to be gullible.
Okay, I got that one more question.
Okay, but we're in the middle of whether we were going to take amendments. So, Floor Leader Hong.
I'm sorry. I have a motion.
I hit the wrong button. She could, this is a proper, yes, that is correct. Yes, hold on, Floor Leader Hong. Yes, Representative Neal.
I'm sorry, it's still on.
Repeat your first amendment again.
My first amendment?
I think she was just giving alternatives.
Okay, so it was just discussion, not in the form of a motion.
Yeah.
Okay, so you were just discussing, you were not making a move to amend.
Well, I had 3 points, but I have my amendment here already.
All right, we did have a motion to pass, and we are in the time for amendments. I caught that Mr. Scandalakis had not testified first, and so I was letting him speak to the bill. Now we are in a posture for amendments. Representative Neal, was that what you were discussing earlier? Yes. An amendment? Yes, sir. Okay, all right. All those in favor, or was there a second to your amendment, or to your proposed amendment?
No.
Okay. All right, here no second amendment fails.
Wait
All right.
a minute.
All right, okay. Back on track. All right. Any other amendments? All right. I'll call the question. All those in favor of the passage of the bill, say aye. Aye. All those opposed, same sign. All right. And Penny the Chair, the ayes have it. Congratulations, you're on the rules.
Thank you.
All right. Move along. Representative Cummings. And this is House Bill 1130. We're about to roll on rocket docket because the clerk's office is waiting. Oh, excuse me, not 1130. I apologize. I need to get new glasses. 1360. House Bill 1360. Go ahead,
yes,
Representative Cummings.
LC 570053. First, I want to thank the committee members and the sponsors for this bill. And this bill is pretty simple. My bill closes an unintended loophole in the drug trafficking statute 161331. Right now, and it deals with fentanyl. Right now, fentanyl is referred to in the trafficking code 161331, but it's referred to as a reference in section A, B, paragraph 13 of code 161325. So it's in there, but it's kind of buried. And there's a legal term, which the gentleman that was here with me the other day said, expressio unis est exclusion arturis. The expression of one thing is to the exclusion of another. So because fentanyl is not directly in the drug trafficking statute, defendants have been able to use it to attack indictments. It's cumbersome when you're trying to charge. And if you're an inexperienced prosecutor, it can create problems. This statute was last updated in 2017. Fentanyl was on nobody's radar in 2017. Now it's on everybody's radar. We know the dangers of it, and it simply adds to Section B, the section that deals with opium, morphine, and heroin, your opiates. It just adds it as another drug, even though it's not naturally made because it's man-made, with the appropriate penalties and corresponding fines. So that's all HB 1360 does. And I have with me today Jason Saliba. He's the Deputy District Attorney of Cobb County, and he'll speak further to the bill.
All right. I know you present testimony in subcommittee.
No, sir. I believe that was Chief Evans from Mackworth Police Department.
Okay. Do you have anything to really add to his testimony?
Not unless y'all have questions, sir.
Okay. Stand by for questions. Any question? Number 5.
I just want to know how many times you had to practice that Latin word.
Words, I guess.
All right. If you want to speak, you came all the way from Corn Cobb County, so.
I'm fine, Mr. Chairman.
All right.
I understand y'all have a lot of business to get
That's
through.
a little joke, by the way. I hope you'll humor me with that. I love Cobb County. It's been good to several generations of my family with a good place to work. So thank y'all for keeping it safe and crime off the streets and putting the bad guys away. Number 14.
Thank you, Mr. Chairman. All right, so I appreciate your Latin term. That was very impressive. You did a great job. And I'm trying to make sure that I understand it. We say that it don't specifically reference fentanyl.
When you look at,
But line 17 on the back, on page 2, it says, subparagraph A, C.5, F, U.1, B, or B.2, paragraph 2 of Code Section 161326. And I'm looking at that, and subparagraph F of paragraph 2 of 161326 says fentanyl. Does it not?
It does.
Okay. Then what is that not? I'm confused.
So you're smarter than about 2/3 of the judges in this state, and I'll say that openly. And you're a lot more intelligent than a lot of prosecutors. So what happens is GBI did that so that as people come in and make analogs and change things, they can go into just the controlled substance code and fix it, and not have to go into each statute that references. What you get in trafficking is you have magistrate judges who are working who don't have a criminal practice, don't deal with this much, and they say, well, I'm looking at trafficking and fentanyl's not in there because of all the different code sections that are listed. They go through and start looking for it, and if they miss it, we have police officers who call up and we're like, why don't you charge this as trafficking? We didn't see it. I don't see fentanyl anywhere in the statute. We have young prosecutors who do the same thing. We proof their indictments and we look at it and say, well, why didn't you charge it as trafficking? Well, I don't see fentanyl. I don't understand. Those are some convoluted ways to get to the word fentanyl. I talked to GBI yesterday, both the deputy director at the lab and the head of the drug division. They've got no opposition to doing this and adding it as long as we don't take out the other language that lets them go in and amend as we get new analogs and new salts and isomers.
Okay. All right. I appreciate it. I was worried I was missing something. Yeah. I was a police officer, so I've read a lot of these, and so
you
I
understand
appreciate you saying that sometimes I was smarter than some judges. Not that one, but some of them.
And I've known him a long time. He is excluded from that comment.
All right. Thank y'all. Pack, anybody? Major?
Like Jason said.
Okay. Well, seems as if this is one of the better aimed solutions to our opioid problem with fentanyl.
Thank you.
And I want to commend the representative for that. It seems as if this has been the best way to approach solving this problem. And I want to commend both of y'all for your hard work on this. That being said, what's the will of the committee? Maybe pass in a second. All those in favor say aye. Aye. All those opposed say no. Congratulations, you're on the road.
My first one, thank you.
Is that your first?
Very first, thank you.
If it gets to the floor, I want you to say the Latin term from the will.
All right. Sorry, we'll celebrate after. We got more work to do. House Bill 1383. Vice Chairman Reeves, you're on.
Thank you, Mr. Chairman. House Bill 1383 is a jurisdictional fix following the repeal of the citizens arrest law. And what this bill does, it allows, upon the request of state law enforcement, for federal officials to assist the state law enforcement and to detain defendants. We had a lengthy, thorough analysis of this bill in subcommittee, and I appreciate those of you who are on the full committee who helped with that. You had 4 federal officers in here wearing badges about twice the size of this one right here, and they were a little bit more well-armed than I am. But they talked about sex trafficking operations where state officials invite them in to assist, and then incidental events such as a big car crash where State Patrol is overwhelmed. They just need more bandwidth with law enforcement. So that's the scenario. Back when citizens arrest was the law, that was the jurisdictional basis for federal officials to detain upon request of state officials' invitation. For state crimes, of course, for federal crimes, they have that jurisdiction by federal statute. So this is mainly a jurisdictional issue that gives clear legal coverage for longstanding operations of federal and state law enforcement.
All right, I can speak to a little bit of this. I'm going to thank Vice Chairman Reeves. We have met with the feds on this, and this was a very simple fix. They did not need the authority to arrest. They just needed the authority to detain, and I want to thank Vice Chairman Reeves for that. I think it strikes a very good balance in between, and so just a little background there. Any questions from members of the committee? All right. Representative Miller.
Thank you, Mr. Chairman. So can you just explain to me the circumstances under which the federal law enforcement, like what you're envisioning, the federal law enforcement agent would detain a person without a warrant?
Okay, specific example given to myself and others when we met with them several weeks ago. Let's say that they're at a gas station, they see an attempted carjacking occurring.
They witnessed.
Under current law, they could not do anything. They couldn't detain nor arrest. And so they have to actually be given specific authorization from the state to even detain. And that's all they want is detainment powers, not arrest. So.
And Mr. Chairman, if I could add, I think this may have dropped out from the subcommittee. The subcommittee got a letter from Homeland Security, and they said frequently either there's an incidental need for federal assistance through like a disaster, like a barricade and crash, or somebody goes through a barricade and causes the interstate to shut down. They just need all law enforcement in the area to assist. And you've got people who are fleeing, suspects fleeing. So that's one. And then expected events where they have like a prostitution, human trafficking, domestic violence, or other intervention where there's a benefit of having federal law enforcement around for gathering of evidence and the federal resources, but you may have a situation where the state folks would need the federal officials to assist with detaining those defendants. And in terms of words on the page, lines 59 to 65 has the real substance of the bill, and it's upon request of state law enforcement.
All right. Okay. Anybody else? Oh, yes, Secretary Crow.
Sorry. So just so I'm clear, and I only caught half of the subcommittee, I apologize. I understand your example, but to the chairman's example, I don't think this would allow for them to detain that just witnessing the crime. They have to be requested to assist by a local or state or county department. Is that right?
That's right, and that goes back to the custom before citizens arrest. The federal officials would just do their federal work, and if they're requested by state officials, they would come in and they would be able to do detaining based on state offenses. But now that there's no jurisdictional basis, they've requested this law to give them a clear jurisdictional statutory basis to assist federal or state law enforcement upon request for detaining individuals.
But if they witness a crime in progress, they can't do anything about that because they've not been given that authority. They've not been requested.
that would kind of fall outside the scope of what the federal and state cooperation is desired. They exercise restraint, and they're there to come in upon request of State Patrol and other state agencies.
Okay, thanks.
That maybe that's a 2025 bill.
Let me clarify. We are giving them the authority to detain.
That's right. Upon
It's
request.
just if they need someone to if they need a federal agent to excuse me. Let me put this scenario a little bit more clearly. They can detain under this current bill that we have before us, but they cannot arrest unless requested by.
They can't detain unless requested by.
Upon request.
And I think the federal officials were reluctant to do the full processing at the jail. They didn't want to get into booking and things like that.
But they can't detain unless we request.
Right.
Okay.
His
All right.
example. That's what I was
Got it.
making.
Got it.
Your example of what you were thinking is what I was thinking, but
Got
when
it.
I read it, I was thinking that what you were thinking, what I was originally thinking, was not applicable to what we're
Okay.
now.
All right.
I think they leave the booking and processing and jail part to the state level folks. It's mainly the being able to lay hands on and detain the defendants that the state officials want the ability to call them in for, and that the federals are interested in getting involved in.
Okay. Number 6.
Yes, so just provide some clarity because we went back and forth on this issue here. So the bill only allows for detain. Arresting is not an option under this bill. Arresting is not an option. To the issue of the paperwork and everything you're talking about at the jail, that's why I posed the question about transport and the definition of if they are transporting, is it detain or an arrest? And that's where I was talking to PAC to get them to speak to that. And if there's anybody else in the room that can speak to that, we would appreciate it. But outside of that, this bill is only for detention and transport, and the definition of arrest and detainment when it comes to transport, that will be left up to the courts. But they are not allowed to arrest under this bill.
This, and my understanding from the conversation with the feds the first time, or when we met about this issue, they do not want the arrest power. They only want the detainment power.
Yes.
Judge Gunner.
During my time as DA, I had a case that was the hiker on the mountain. And this would have been very good to have to put the word out to federal law enforcement. If you run into this person, we need you to detain him so that we can deal with it. Because we were searching for our victim and one step behind, trying to catch up. But we had a description of his van. We actually had a photo ID of him. We knew who he was. We just couldn't catch up. And something like this would have been very helpful.
Thank you, Judge Gunner. All right, number 11. Chairman Silcox.
Thank you, Mr. Chairman. I was gonna make a similar remark. In Chairman Smith's example, if they had already had if local law enforcement had already identified a crime and they had a stakeout on a certain area, or to look for a hiker or to look for someone committing a crime, I think that to answer Representative Crow, I think they could go and detain that person as long as there was an alert, like you said, by local.
All right. Number 8. Representative Miller.
Thank you. I just wanted to clarify a couple things. So I'm sorry I wasn't in subcommittee, Representative Reeves, but if a federal law enforcement agent under this bill, let's say, gets a BOLO or a request from, APD to detain someone that they run into at a gas station who's not committing any other crime, and that person takes off running or a struggle ensues, and depending on what they're wanted for, deadly force may or may not become an issue, or some kind of force to effectuate this may or may not become an issue. Okay, there have been several high-profile cases across the country involving federal task forces and the applicability of Section 1983 for citizens who have their rights violated, who can bring that claim in federal court, because the rules that apply to the feds are different than the rules that apply to local police officers. And so I guess my question is, has that been anticipated in this bill? And you may not know the answer to it, but I do know that this is an issue that has been raised, Bivens versus 1983, and whether or not a citizen has the same rights, the mechanism to enforce civil rights violations when it is a federal officer.
Here's what I do know. 48 states have an explicit statutory jurisdictional clearance like what the feds are requesting in House Bill 1383. So Georgia's now one of 2 states, and we didn't really do that intentionally. With good intentions in repealing citizens' arrest, we didn't know that was going to remove the sole basis for feds to lay hands on a state law offender. Again, under federal law, the federal officials can arrest, detain, everything. But for state offenses only, there is a gap in the jurisdictional landscape right now that would be filled by this bill. And also, again, the federal officials, they have restraint. They're not out there initiating this. What we're doing is we're giving some legal clearance for the long-standing operations of federal and state law enforcement cooperation.
Okay, chair's going to call a 10-minute recess. We'll be back in 10 minutes. All right, we're gonna come back to order and get going. Some people have some plans. I understand. I try to accommodate that as much as possible. Okay, we got some clarification. It's still supposed to be upon request. So, anyways, I had a lot of lights blinking earlier. All right, so. All right, we heard testimony from this. Anybody have something they want to present that have waited till the last minute? Okay, what's the will of the committee? Move and a second do pass. All those in favor say aye. All those opposed say no. Congratulations on the rules. With that, I'll see y'all at 8 o'clock in the morning. We are adjourned.